Employers, are you concerned about the cost of workplace injuries? Having a strong return to work program can help. Hi, my name's Amy Rich. I'm coming to you from the Texas Department of Insurance, Division of Workers' Compensation. The division provides education to system participants like healthcare providers and employers about having a good return to work program. So the education varies just a little bit depending on who we're speaking to. The main message remains the same, and that is returning an injured employee back to the workplace as soon as it's medically safe and appropriate can help them heal better and faster, and they're more likely to keep their job. And employers can keep their costs down, both human and financial costs, and even more so, cost to society. Now, you may or may not have workers' compensation insurance coverage for your employees. I will talk today in this webinar about the advantages of carrying workers' compensation coverage and some of the challenges for those employers that choose not to. Although we can have some serious injuries in the workers' compensation system, most of the injuries are temporary in nature. And we see returning to work as a shared responsibility. Even a sprained strain can spiral out of control if it's not handled appropriately, and it can cost you, the employer, and it can change the injured employee's life forever. Now let's get started. What is workers' compensation coverage in Texas? It is a state-regulated program that is a no-fault, no-blame insurance system. The Texas Department of Insurance, Division of Workers' Compensation, regulates the workers' compensation system in Texas. Federal employers are regulated by the Department of Labor. We regulate the private employers of Texas. It is a no-fault, no-blame system, meaning if someone gets injured on the job, they just have to prove that it happened on the job, regardless of whose fault it is. This insurance coverage program pays the medical bills related to that injury and also replaces some of the lost wages for that injured employee. Texas is a leader in the workers' compensation system, and we are unique. One of the things that makes us unique is that workers' compensation insurance is not required for most private employers unless they are a government or an educational institution. Now let's take a look at some of the numbers relating to Texas workers' compensation. The information on this slide is from the Division of Workers' Compensation's biannual report filed with the Texas Legislature in December 2024. It shows some good news in that workers' compensation premiums are down 81% since 2003. So if your company has chosen not to cover your employees with workers' compensation insurance, thinking that the premiums are too high, you might want to take another look. The percent of private employers that have chosen to carry workers' compensation insurance is at 76%. This means that 24% of private employers have chosen not to have coverage, representing 13% of employees. This is the lowest non-participation rate since 2016. Other important numbers show that healthcare costs are down by $338 million since 2012. And our injured employees are receiving initial care within 7 days or less. Also, the workers' compensation system shows that the number of prescriptions is down 73% since 2009. And lastly, information related to the topic of this video are the return to work numbers. The report shows that 84% of employees that were injured in 2022 returned to work within 6 months, and 91% returned to work within first year after their injury. Although these numbers look great, we will talk more about return to work and medically unnecessary time away from work after an injury later in this video. For the employers that have chosen not to carry workers' compensation insurance for their employees, we call them non-subscribers. Now, they can have small accident plans or umbrella policies, but it's not the same as workers' compensation coverage. Their employees retain their common law rights, meaning they can file a lawsuit and assign blame for their injuries and their perhaps deaths occurring in the workplace. So those small accident policies or umbrella policies may not pay for court costs and for those attorneys that represent you in the courts, or even for the awards if the courts award pain and suffering or punitive damages. Imagine one of those court cases can put your company in jeopardy, and those risks need to be taken into account when deciding to cover your employees with workers' compensation insurance or not. So even if you're an employer that does not carry workers' compensation coverage, some parts of the law do apply, and that is reporting requirements. On an annual basis, you need to let the Division of Workers' Compensation know that you do not carry coverage. The coverage reporting time is between February 1st and April 30th. And you also need to let your employees know upon hire and posting notices in the workplace that you do not carry coverage, or if you drop coverage during that time. You also need to report to us, the Division of Workers' Compensation, if there's an injury or death in the workplace. You can use the DWC Form 005 to report your coverage information to the division, and a DWC Form 007 to report injuries or deaths in the workplace. Again, these are requirements that apply to non-subscribers. A lot of the rest of the law does not apply to non-subscribers. If you do not follow these reporting requirements, it could be an administrative violation and you can be fined for not filing that information with us. The forms and notices can be found on our website, and there's much more detailed instructions on those forms. Now let's go over some general definitions. The first one is an injury, or what we call a claim in workers' compensation. That can involve physical damage to somebody's body, or it can involve occupational diseases or infections, and even psychological trauma. So when we say injury, it includes all of those situations. For a claim or an injury to be covered, we call that being compensable. It has to have happened in the course and scope of their job, it being the accident or injury. The course and scope of their job means that they were doing something that was required by the employer, you, and that it has to do with your business, and it furthers the affairs of your business. That's course and scope. So if those things are in place, it could be compensable and covered. In the Texas Labor Code, which is our law, there are some exceptions to liability, meaning the insurance carrier doesn't have to pay in certain circumstances. There are 6 exceptions in the law. I've written 3 in this slide. One is if they intentionally cause their own injuries. The second one is horseplay, or if they were intoxicated on the job. There can be an exception to liability. And the last one, say if they're participating in a voluntary sporting event or a picnic, something that's not required by their job and they get hurt, that can be an exception to liability also. To see the full list of the exceptions to liability, go to 406.032 exceptions in the Texas Labor Code. So for those employers that are covered, meaning subscribers, you're going to gain legal protections. The employees don't retain their common law rights. So you're going to be paying premiums to the insurance carrier, and the insurance carrier is going to turn around and pay benefits to your injured employees. Let's get into what workers' compensation does. If an employee sustains a compensable injury, they are entitled to medically reasonable and necessary treatment for the life of the claim. If it's medically necessary and it relates to the compensable injury, there is no end date. Even if a doctor assigns a maximum medical improvement date, that means they've set a date that this person is as good as they're going to get and there's no further medical recovery anticipated. It also replaces their income. Temporary income benefits pay 70% of their average weekly wage until they reach maximum medical improvement, or MMI, or 104 weeks, whichever is first. The second thing it does is if there is a death, unfortunately there are some fatalities in Texas workers' compensation, the coverage is going to provide benefits to the families of people that are killed on the job. So if there is permanent damage to the injured employee, to their function, a specially trained doctor can assign an impairment rating. That's a percentage, and each percentage point can equal impairment income benefits to that injured employee. Also, if there's a catastrophic injury, there can be lifetime income benefits. So workers' compensation coverage limits the employer's liability. Imagine an employer trying to pay for a large hospital bill, or maybe even a lawsuit if they go without coverage. That can put someone's company in a bad position. So this provides coverage for the injured employee and for the employer. It protects the employee by paying their medical bills and having income replacement. It protects the employer for paying those benefits. Also, workers' compensation law prohibits an employer from firing somebody just because they got injured on the job. The workers' compensation system provides a dispute resolution system. So if there are disagreements about, say, the maximum medical improvement date or the impairment rating or whether or not they can return to work after an injury, we have a whole regulated system of hearings, proceedings that can resolve these disputes between system participants. So how much are you going to pay if you choose to have workers' compensation coverage for your employees? It comes down to 3 factors. One is your industry. Say an administrative job versus a construction job. If you are a high hazard employer, you could have a higher premium. So that's one factor in deciding your premium amounts. The second one is your payroll. That is something you report to your carrier so they can calculate how much it would be to pay out a claim. The last one is your experience. The insurance carrier is going to look back at 3 years and see how many claims you had and how severe were they, how much lost time was involved, and say the benefits that were paid out. So just like any other insurance carrier, they're going to be looking back at 3 years to determine your premium. All of this calculates into your experience modifier. So how do you control your cost? On the left-hand side is your cost, and on the right-hand side are some solutions. One, the severity and frequency of injuries and illness can cause your premiums to go up and cost you a lot more in human cost also. So how do you mitigate this? One is your safety culture. Do you have a safety culture? Do you have procedures and protocols in place to keep your employees safe? Are you training people on that? A lot of times employees get injured in their very first year of working at a company. So make sure that someone is onboarded and trained before they get back into the field or on the floor to perform those jobs. Also, are your managers and supervisors trained? Is there enforcement of those procedures? I also would recommend involving the employees in setting those safety protocols. Then you will have more buy-in. Also making sure your supervisors and managers are being held accountable so that safety protocols are followed. The second issue for cost is medically unnecessary lost time. And yes, there are times where people are away from the job after an injury that is not medically indicated. It's not for a medical reason. So how do you deal with that? 2 things. One is have a stay at work while they recover mentality and program, and a return to work program. Have that set in place for those employees that happen to get injured on the job. That way the doctor that's treating them, the employee knows, everybody knows that there is a return to work program and that it's going to be encouraged and communicated and facilitated. That will help eliminate medically unnecessary time. One study showed that 60 to 80% of workers' compensation claims involve medically unnecessary time. So remember that 92% I was talking about? There is a possibility of unnecessary time away from work, even if they return to work after a year from their injury. Is your safety culture like this? Is everybody involved here? Is that a supervisor or a manager there holding the ladder for your trained, experienced employee that may get hurt? Remember, accountability enforcement is important. The goal is to help your injured employees recover and get back to work as soon as it's medically safe and appropriate. Again, all system participants have a responsibility in this, including the injured employee. We want to remove barriers for your injured employee to make the decision to come back to the workplace and know that they can recover safely while on the job and return to work after medically necessary time away from work. On our Return to Work page on our website, we have this infographic, and it shows and depicts the shared responsibility in returning someone back to work. We all should be supporting and talking to that injured employee about return to work. On the left-hand side is the healthcare practitioners. These are the doctors that take care of your injured employees. We expect them to provide high-quality medical care that cures and relieves the effects of that injury. and also to talk to the injured employee about the duration of recovery, and they should support and facilitate an injured employee's decision to come back to work, and they should decide what they can and can't do safely, and they should communicate that to the injured employee and to the employer. Now, as far as the employer goes, the healthcare provider cannot make employment opportunities available in the workplace. That is your job. Your role is to provide that return to work program, meaning offering a place that the injured employee can recover safely in the workplace. Making employment decisions and providing return to work opportunities is your role as an employer. The last entity involved is the insurance carrier. Now, they should know all the laws and rules, and they should also be talking to the injured employee about return to work. Make sure your employees know that the adjuster from the insurance carrier will be contacting them, and that is one of the things that they'll be talking to the injured employee about. And the Division of Workers' Compensation, like what I'm doing today, and that is providing you information about return to work. We also have regulation in place that helps all system participants. Guidelines, outreach, and oversight is part of our job. Again, we should remove barriers for the injured employee to come back to the workplace after an injury. Let's focus in on medically unnecessary lost time. It's going to cost you, if someone is out, you're going to be paying someone back at the workplace either overtime or temporary costs because someone is absent. And you're going to be paying income benefits. So that's paying somebody at home and somebody back at the workplace for the same job. You're going to have medical bills. The longer they stay at home, the more medical services they may incur, and that adds to your costs. Also, sometimes people are replaced after they're injured on the job, so you could have staff turnover, or they decide to leave the position. And you know how hard it is to find a qualified applicant these days and to train them and onboard them. Keeping your trained, experienced employee on the job is better for everybody. You won't have delays in production, perhaps. Things won't slow down as much as you think if they're coming to work in a return to work or maybe a transitional job while they're recovering. And ultimately, your premiums will stay down. Having a stay at work or return to work program is important to mitigate those costs. It's going to benefit you, the employer, and your bottom line, and that is it's going to reduce turnover and training costs, reduce absences. You're going to maintain your quality and production standards. You're going to reduce your business costs and your workers' compensation premiums, and you're going to be paying wages for actual work done, not just benefits and hiring somebody on a temporary or overtime basis. The other thing that's huge is that employees are going to heal better and faster while they're on the job. It benefits employees by having a return to work program. They're more likely to retain their job-related benefits. For instance, keeping their health insurance or paying into Social Security or Medicare. If they're coming to work and possibly even keeping their job, they're going to keep those job-related benefits going. They're going to avoid financial difficulty. I don't know about you, but receiving 70% of my average weekly wage is going to put some pressure on me, and I'm already in the shock of having an injury. Add the financial pressure to the family and to that person is going to be difficult. So having a return to work program helps with that. Someone is going to stay in better physical and mental health if they are staying connected to the employer and to the workplace. Their coworkers provide a social support to them, as well as just getting up, getting dressed, and coming to the workplace. Sitting is the new smoking, and if they're not getting up, they can get sicker. Comorbid conditions can set in. We don't want that for our trained, experienced employees. Now, we all know what it's like to be isolated and at home. Over the last few years, people can get sicker while they're at home. We don't want them to look like this and feel like this. Medically unnecessary absences. Sometimes there's things that are out of our control. Like, for instance, they already had family or personal problems going on. Add a workplace injury to it is going to make it much more difficult for them to recover. Now, I know that sometimes you think you cannot affect that, but creating a culture of loyalty in your workplace helps mitigate some of these issues. Also, they may have fear. They may not think that they could come back to the workplace safely. Now, if you create trust between you and the injured employee, telling them that you are going to abide by the restrictions that the healthcare provider communicates to you, that will help alleviate some of the fear of maybe re-injury or getting worse when they come back to the workplace. Maybe they never liked their job or don't like their job now. One of the key indicators of whether somebody decides to come back to work or comes back to work is their relationship with their direct supervisor. That is key to someone's workplace health, and especially after an injury. So make sure your supervisors and managers are trained. Not all frontline employees make good managers. Again, training, enforcement, and accountability, and creating that loyal culture in your workplace will help combat some of these things that are outside of your control. So if they have a job like this is deodorant tester, would they hurry back to work after an injury and they don't like their boss? You can see how that can affect an injured employee's return to work. So sometimes employers can be their own worst enemy. I know some large employers that say, I don't want an employee back to work unless they're 100% better. Well, a lot of us here in the workplace are not 100%, and they are at the workplace. It's keeping them healthy. We know that work is healthy for people. There is a study that shows the highest mortality rate are for those people that are off work and on disability. And people that live the longest are those that continue to work. No surprise there, right? Also, employers can say, well, there's just no work available. They can't be a truck driver. I have nothing in the workplace for them to do. Pay attention to that. I think if you have jobs that have repetitive injuries in those jobs, think outside the box to create a return to work program and a temporary assignment for them, especially if you know ahead of time this is a problem area in your workplace. Maybe you think you're just too busy to deal with this. Well, it's going to cost you. Those insurance carriers are paying your money out for benefits and for medical bills. And also, you can lose your trained, experienced employee. Sometimes you think it's the insurance carrier's job. Again, everybody shares responsibility in getting someone back to work, and it can affect your bottom line. Supervisors and managers, I can't stress enough that they need to be using that mentality from the top to the bottom, that return to work is a good thing for people. It's healthier for people to work. Also, as an employer, you have a role to keep your employees safe according to the Occupational Safety and Health Act of 1970. You should ensure safety at all actions reasonably necessary to keep your workplace safe. The least expensive injury is one that never happens. So OSHA needs to be kept in mind when keeping your employees safe. So before an injury, I talked about making a culture shift or change. That is important before an injury happens, so that you set the stage for someone to, if they got hurt, to come back to the workplace and regain their function. So post notices of coverage, that is in your workplace, like we talked about earlier. You need to let your employees know whether you have workers' compensation coverage or not. You need to educate and inform those employees about the coverage, about your safety protocols, and what to do if they got injured. They need to know what to expect. Is the adjuster going to be calling them? Are you going to be contacting them? One of the things that I heard in one of my conferences is that just having a box of get well cards, I know it sounds kind of facetious with the digital age, but think about that. Everybody staying in touch with that employee while they recover is important to their health. They know that you want them back in the workplace. So involve your employees with setting up this return to work program. Also, do they know who to call? Designate and train a contact person, and hold supervisors and managers accountable for enforcing this. So we talked about before an injury happens, now after an injury happens. The employer should immediately report that injury to their carrier and also report their wages to the carrier, because the carrier has duties after that we regulate and monitor their actions after a claim is filed. Also, you, the employer, are going to investigate that injury because you want to know how it happened so you can prevent it from happening again. And should probably send somebody that's objective, that's not into blame, to go in there non-judgmentally, but also just find out what happened so you can keep your employees safe. Maintain continuous positive communication with that injured employee, like the Get Well cards. Monitor your claims regularly. Talk to the insurance carrier, to the adjuster, and see how it's going. Also, the adjuster is an extension of you. They need to treat your employees with respect and open communications. This should not be a secret that return to work is good for the employees, and having a return to work program exist in your workplace. Also, I talked about dispute resolution, where there can be hearings resolving some of those disputes. You can attend those hearings. You can provide facts. You can support your injured employee. Also, most importantly, no one else in the system can make employment opportunities to an injured employee have a return to work or stay at work program. I talked about this a little bit earlier, but the Texas Labor Code prohibits you from retaliating against an injured employee. That means you can't fire them just because they got injured on the job. It is a no-fault, no-blame system. Also, you can't tell the doctor what types of treatment. You're not entitled to medical records and test results, that sort of thing. And you can't tell the injured employee which doctor to go to and which one not to go to, unless you've chosen to be part of a certified workers' compensation healthcare network. And if that's the case, the injured employee must choose a doctor within that network. Also, if there is a question about whether the injury happened in the course and scope of their job, which we call that a compensable injury, if there's a question about that, send the information that you have about compensability to the carrier and let them do their job of investigating and perhaps disputing the compensability of that injury. That way you could stay in good relationship with that injured employee and help them return back to the workplace as soon as it's medically safe and appropriate. The insurance carrier, they have a significant role in the system. They're paying the benefits out to that injured employee. They should know all the laws and the rules, and they're going to investigate too. So as soon as you file that first report of injury, the insurance carrier begins that investigation. And they can dispute compensability. And if they do, it will go through our dispute system at the Division of Workers' Compensation. They're going to monitor all claim activities. Are the injured employees going to their doctor's appointment? Is their case manager assigned? Who have they been referred to? They're going to maintain communication with that injured employee. They should be talking to you, the employer. They should talk to the doctor and all the other providers that are providing medical care to your injured employees. They also can provide information and education. Again, this is a shared responsibility. In the workers' compensation system, we have other regulation that helps and facilitates someone's return to function and back to their lives and their workplace, and that is evidence-based treatment guidelines. This helps the doctor provide high-quality medical care to our system, to our injured employees of Texas. We also have return to work guidelines that provide duration and time frames for someone. Say they have a back injury and they have a sedentary job. It'll give points and times where the insurance carrier and the healthcare provider can look at and say, hey, this person might be getting into delayed or failed recovery, and we need to take a closer look at this claim and see what are the reasons why someone is not returning to work. The statute requires the insurance carriers to provide return to work coordination activities. Please ask your carrier what return to work coordination activities that they are providing to you, the employer. They can also maybe assign a case manager if it's a more complicated case, and that person just helps coordinate the care with all the providers that are helping that injured employee return to their lives and back to the workplace. The treating doctor, an important role in our system. They should be providing high-quality medical care for that injury and determine when it's safe for an injured employee to get back to the workplace, and what restrictions that they place on that injured employee while they're recovering. They communicate this on the DWC 73. That's the form here in your slide, as a work status report. This is something that needs to be filled out by the doctor and provided to the injured employee and communicated to the injured employee, and also that form comes to you, the employer. If you have any questions about the DWC 73, the work status report, please pick up the phone and call that doctor. There's nothing wrong with talking to the doctor about work status and what they can and can't do safely. And it needs to be transparent. You can tell the injured employee, I don't quite understand, let me talk to the doctor and get clarification. That is okay. Again, you're not entitled to medical record information, but talking about getting someone back to work is important discussions. And we expect the doctor to support and facilitate return to work. Also, something you can do as an employer is you can help the doctor by explaining what the injured employee does back at the workplace. Right now, the doctor is just relying on what that injured employee is telling them. You can participate by filling out the DWC 74. It's the sister form to the work status report. It's not required, but you can use it. So for instance, on those jobs where you see that there's frequent injuries, have one filled out so that you can send with the injured employee to the doctor so the doctor can make good decisions and discuss with the injured employee what they do and what they maybe perhaps just taking a small part of their job and saying that they can do this but not that. So it divides up someone's job into functions, duties, specific tasks, work activities, and the physical responsibilities of their job back at the workplace. It looks similar to the DWC 73 in this section. This is where the restrictions are placed on the work status report. Same exact thing on the work, the description of their employment that you can communicate back to the doctor. And maybe you involve your employees in filling this out. Maybe the supervisors and managers are a little bit removed from what the frontline people do. This is something everybody can participate in. Again, it's not required. It's just a helpful form on our website under the forms section. The work status report, look at it, looks exactly the same as the DWC 74. Also, this is where a doctor can decide if someone is released to full duty. That's the first option. The second option is they can go back to the workplace with some restrictions between this date and this date. And the third option is if they take someone off work completely. Now, we monitor the healthcare providers and their performance in our system, and one of the things we pay attention to, if a doctor is taking an injured employee off work completely, we want an explanation in this section. The doctor should be fully explaining to you why someone cannot do anything back at the workplace. Making stay at work or return to work offers to the injured employee. Sometimes we use the word light duty, but we want them to do real work back at the workplace. It'll help you. Maybe you don't have to hire a temporary person or have someone do overtime while someone is recovering. And also, purpose is important to an injured employee. If they're coming back to the workplace and separating paper clips, that's not great for anybody. Yes, they're getting dressed and getting to work, but if they can do something that's meaningful, that helps further the affairs of your business, take their job description and break it down by tasks, duties, and activities. That will help you carve out something that they can do that's meaningful and helps the bottom line of your company. We have some help in this area. On our website, we have the Employer's Return to Work Guide. That will help take someone's job description and break it down into tasks and duties. So here on this slide is the QR code to get directly to the Employer's Guide on our website. So once you receive the work status report, it's going to tell you what the employee can do safely and what they're restricted from doing. And you're going to be making work assignments, and that should be real work assignments that adhere to the restrictions that the doctor communicates to you on the work status report. And that also creates trust between your injured employee and you if you're following the restrictions of what the doctor says. Also, it'll keep them from being re-injured and getting worse. Making those offers, maybe it's a transitional job or a temporary job. Maybe it's a new assignment. Maybe their coworkers are going to help them fulfill all the duties related to their job. Think outside the box. Maybe it's just a different way of doing things, like this. Maybe their coworkers are going to help them reach those shelves or put that box away. Think outside the box and have the coworkers involved. It's supportive to that injured employee also to have their coworkers help them. This is a math illustration for you to show you that having a return to work program benefits everybody and everybody wins. On the left-hand side is someone staying at home full-time after an injury, and on the right-hand side is someone that comes back to work on a part-time or half-time basis. So on the left, they're staying at home full-time. You, the employer, is going to get no work from them. You might have to hire somebody that's overtime or temporary worker to help you fulfill the duties of that lost employee. So in this case, this person makes $500 as an average weekly wage. They're only going to get 70% of that, so that's $350 while they're at home recovering. So the employee gets $350 in income benefits, and they're probably going to recover slower. Remember, if they go back to work, they're going to heal better and faster. On the right-hand side, that's when somebody comes back part-time. So you're going to get real work half of the time. You may not have to hire overtime or temporary workers. So you're going to be paying 70% of $250, which is half of their average weekly wage. So they're going to get $175 in benefits and $250 for the half time they are working. So $250 plus $175, that's $425. And they're going to heal faster. That's a win-win for everybody. So the Division of Workers' Compensation has lots of resources for you, the employers. Number one, we have a whole web page dedicated to employers. It has fact sheets, it has information about income benefits and questions that are answered for you on that web page. So if you just follow our website to the employer page, you will see all that information for you. We also have a return to work page. This is solely dedicated to giving all system participants information about having a strong return to work program. We have tabs on that web page for each system participant. So you, the employer, you'll have your drop-down tab, information for you. The healthcare provider has their tab, and the insurance carriers have their tab also. It has that infographic that I shared earlier. We have return to work training like I'm providing in this webinar today. If you need more education on return to work or have questions, you can certainly call us. We provide this type of education to the healthcare providers themselves to help them facilitate and encourage return to work. That's part of our duty and our role in this shared responsibility of returning someone back to the workplace. Also at the Division of Workers' Compensation, we have a program area called the Occupational Safety and Health Consultations. It's called OSHCON. It provides you, the employer, a free and confidential survey of your workplace safety for OSHA compliance. We also have resources and videos, all to keep your employees safe in the workplace. We recognize employers that have a good safety record called the Lone Star Safety Program. We have field offices all over the state of Texas that have these consultants ready for you if you were to request a consultation on OSHA compliance. The contact information is here on the slide for you. If you have an injured employee struggling through perhaps the dispute resolution system, there is free assistance offered to them at the Office of Injured Employee Counsel. Now, this is a different state agency from the Division of Workers' Compensation. They provide ombudsman services to the injured employee free of charge. As long as the injured employee is not represented by an attorney, they can receive the Office of Injured Employee Counsel. The contact number is here on this slide. You can also contact me if you have questions about return to work. There is an email box and there is a telephone number. Please contact me if we have any further questions, and you can visit our Return to Work webpage. Thank you for listening to this webinar, and we're going to go to questions and answers live next. Hi everybody, this is Amy Rich. I was your presenter today. I'm also the Return to Work coordinator for the Division of Workers' Compensation. I just wanted to thank you along with my coworkers for joining us for our very first comp course. This is where we're going to be offering topics to system participants about workers' compensation, yay, and also offering you continuing education credits. So that's all good. If you haven't signed up for our e-news to get notified, please do so. You can get notified when we schedule the next comp course. Now we're moving into Q&A.
and I'd like to throw out there a few ground rules. One is that if you put your questions in chat, but please refrain from putting case-specific information in there because we want our claimants' information to remain confidential. Also, it's a little bit tough for me to answer claim-specific questions. At the end and during the presentation, you've got an email address to send those questions to. Certainly, we'll talk to you about your claim-specific questions. So email me later so I can follow up. Now, I may not get to everybody's question, or maybe I don't know the answer to your question. I will get to that if you email me later. So without further ado, I want to talk about the chat. I've been watching. We didn't have many questions during the presentation, so I'm going to be reading them and trying to answer them as I go. Again, if I don't get to your question, please email me. And we're going to throw up that slide. Also, you'll have an email address for your continuing education questions also. Let's see. I also put in the chat a few links. One is to the employer page on our website, which is very extensive. It's robust, and it has frequently asked questions. It has a video for employee workplace safety. Also, the next link was to the Return to Work guide and the Return to Work webpage. So each system participant has a role in returning people back to work. So we have a tab for the injured employee. They have a checklist there. They have resources. Also, the employer, where you can find the Return to Work guide and other resources, the healthcare provider, the insurance carrier, and the Division of Workers' Compensation, all on the Return to Work page. So here we go with the Q&A here. Let's see if I can go through this. I appreciate the compliments. Thank you. Let's see. Rule 129.6. That is the rule that talks about bona fide offers. So if you're interested in that and you're offering a modified duty to your employee, you can work with your carrier to make a bona fide offer. So you will be following the restrictions that the doctor has outlined in that bona fide offer. So the rule number, if you'd like, is rule 129.6. Somebody may put a link in the comments for that. So let's see. Can the employer lay off the injured employee at any time? Well, first of all, if it looks like retaliation, you might need to be concerned. So this is where your HR policies, your leave policies come into play. I think I typed in the notes that FMLA may come into play, other ADA requirements. So if you're subject to those federal laws, you need to take that into consideration when you're determining your leave policies. The leave policies need to be clear and communicated to your employees. And if you need to replace that employee, you can just follow your policies to a T, whether they're off for some other reason or a work-related injury. Make sure they're clear and communicated to your injured employees and to take those federal laws into place. You don't want to do anything that looks like you fired them just because they got injured on the job. So I can't say that it's at any time. It's follow your HR policies. And if you do not have leave policies, please create them and follow them consistently, because anything that looks inconsistent may look like retaliation. Why can the employee stop showing up for work and not see a provider and claim he should be paid lost time? How soon is the employee expected to see a provider for lost time? The employee can choose to get medical care at any time they want to for work-related injury. They're entitled to all medically necessary care for the compensable injury. Your carrier, if you have a question about whether they're due temporary income benefits, please talk to your carrier and adjuster about that question. So somebody asked about the bona fide offer. Again, that's in Rule 129.6 in our Texas Administrative Code, and it is a letter. Also in the Return to Work Guide, you'll find more information about the bona fide offer. It is when you're making an offer to the injured employee about returning to the workplace in a modified duty. Not all people use modified offers. A lot of times it works really smoothly. People know ahead of time that there's a return to work program, and they get back to work as soon as it's medically safe and appropriate. Also 129.6, because of Allison's question, what happens if you offer return to work, but the employee refuses that offer? If you make a bona fide offer, then you will have a clear communication from the employee on whether they're going to choose to come back to that or not. And the carrier can start taking that into account when determining income benefits. So please stay in touch with your carrier about your bona fide offers and whether or not the employee refuses that offer or not. Also 129.6 gives you more information about staying within the work restrictions that the doctor offers, geographically accessible, that sort of thing. Okay. Can a workers' compensation doctor suggest to the injured employee a lawyer? Well, we can't stop the doctors from making suggestions to that injured employee. The injured employee can retain legal counsel if they would like, if they're covered by workers' compensation coverage, or if they don't have an attorney representing them, they can have ombudsman services from the Office of Injured Employee Counsel. Can this be shared with the insurers? Of course it can. We're going to be posting this video on our website. And also I see that someone posted the rule 129.6 for bona fide offers. Again, more questions about whether the employee refuses an offer. You're going to find more about this in 129.6, and also chapter 129 in general is a good place to look. 129.2 talks about entitlement to temporary income benefits. So you can look at that rule. Can you reiterate what the employer can do and say to the treating medical provider that is within the guidelines besides the 74, a letter stating they have returned to work? We encourage communication with your providers. So don't be afraid to talk to them before accidents happen. Tell them you have a return to work program. Get to know them. You can't direct where an injured employee goes to for medical services on non-network claims. They can choose any willing provider. On the network side, you need to let the employee know that they must choose from the list of contracted healthcare providers. What you can talk to with the healthcare provider is all about return to work. Now, if you want to talk about their medical, you could try to get a release of medical information from the injured employee, but generally speaking, talk to your carrier about that information and why you need it to make return to work offerings to that injured employee. Majority of the time, you'll be communicating with the healthcare provider about return to work information and just clarifying the restrictions, what they can and can't do safely. We want you guys to encourage them working through their recovery, as long as it's medically safe and appropriate to do so back at the workplace. So somebody asked, when do I file the report of injury? Do I do this immediately? Chapter 120 in our Texas Administrative Code is all about your responsibilities as the employer on when to report an accident or injury. 120.2 specifically talks about filing the first report of injury as soon as there's lost time that first day, or if there's a death, unfortunately those happen, or an occupational disease where you found out that happens. 120.2 of somebody, oh, thank you for putting that into the chat. I believe you stated that employers are not allowed for medical records, not without a special release from your employee. And I would also ask, what is it necessary to have their medical records? Talk to your carrier about why you need that information. They're receiving the medical bills and medical records accompanying those medical bills. So talk to your carrier. You can talk to the doctor about what they can and can't do safely, and about your return to work program. Somebody posted, how would you address work restrictions that state an employee is unable to work? Can you request that the employee see another doctor for a second opinion on that injury? Your carrier can ask for the injured employee to go see a designated doctor to have that assessed. Also on the 73, we ask, I think I said that in the presentation, that if the doctor is going to take someone off work completely, they need to explain that in the section on the DWC 73, why they can't do anything. But talk to your carrier about your question, why they're unable to do anything, and maybe the carrier can request a designated doctor exam. What does the employer provide to the employee after an injury? Good question. First of all, you can find more information about this on the DWC website under the employer tab, but you're going to give the employee their first report of injury, copy of that report, the DWC 41, which is the employee's first report of injury, and their rights and responsibilities. You'll find all of this on the employer's webpage. And if the claim, the injury, is part of a certified workers' compensation network, you need to notify the employee right then, well, upon hire, and then after an injury, that they're part of a network and that they need to choose a doctor from the list of healthcare providers in your network. Okay. We also, the Division of Workers' Compensation, as soon as we find out about the injury, we're going to send a packet to the injured employee also with their rights and responsibilities. Okay. Are designated doctors only chiropractors? And how is the designated doctor selected? Do you match specialty? We have a designated doctor scheduling area on our website, in our division. And no, designated doctors include MDs and DOs and chiropractors. So we will match up. There's also a qualification standards table in our chapter 130. If you want to know more about that, Michelle, please email me and tell me the reasons why or what you need to know about the qualification standards, and I can give you the specific rules about that. So we definitely have qualification standard tables, and we select the designated doctor that's best qualified to address that injury. Is it okay for an employer to require that an employee participate in PT, physical therapy, after hours or late in the day so that lost time from work is reduced? You can ask, but maybe they can't get in until, when the PT has open times. You can ask, but can you make them know? Can you contact the facility to discuss PT scheduling? I say if you'd like to, yes, but again, you can't direct medical care. So try to do your best to convey your concerns, but you can't make them do that. So the employer resource page was put up on the website, and the rights and responsibilities also, so that's good. And to sign up for notices of future CompCourses is up there in your link. Oh, also, can you let them make up the hours for physical therapy or medical? Again, you're going to have to develop your leave policies and follow them to a T. And if you have questions, please, none of this return to work information should be a secret. We're trying to keep people healthy and back on the job and back to their lives. Can you make that happen? No, but can you ask? Sure, you can discuss it. On your page right now, you can see the email address for those questions that I did not address, or maybe you had questions for the answers. Follow up on any questions there. Also, if you have questions about your continuing education credits, that's the email address to the right. We really appreciate you attending the comp course today. And also, let me look a little bit at more questions that may have come in. We have a few more minutes, like 2 more minutes. Can an employer deduct time while the employee leaves work to get to treatment and return the same day? I think you need to talk to your carrier about that, because they're going to be adjusting income benefits depending on how much they work and how much they don't work. Also, your leave policies need to be clear. So if you want to email me later, maybe I can get a more specific answer for you on that question. Okay, the first report of injury again is 120.2. And somebody also put in a question: if you deduct time to seek medical care, you need to contact your carrier because they will have to pick up time and pay for it. Yes, of course, communicating with your carrier is very important in the workers' compensation system. They should be your partner in it. They're an extension of you. If you have questions, please contact them. Are there any local workers' comp trainings for employers specifically on DWC forms? I don't have any on the books, but again, we're doing these comp courses and we're going to be selecting other topics. Thank you for the idea. Be signed up for our email news so that you can hear about future offerings. I also do this presentation at the Texas Conference for Employers. It's offered by the Texas Workforce Commission, and they're all over Texas, but it's similar to the presentation for today. So we are at a few seconds later. I really appreciate you attending the comp course, our very first one, and be on the lookout for our next one. Yes, every form out there has instructions on the back. You're welcome. You're welcome. Thank you so much.